Hello and welcome. Last time we discussed, among other things, the difference between knowledge and belief. When we meet new people, we often ask what they do for a living, and we form various conclusions about our perceived values we assign to that new acquaintance. It would be an interesting exercise if instead of asking that question, we asked someone we'd just met if they would explain the difference between knowledge and belief. A totally different question, and no doubt we would arrive at quite different conclusions from their answers. The focus, after all, would have moved from the physical realm of our relationships with the external world to an intellectual or spiritual one, indicating somewhat the value we each placed on our consciences and the degree to which we held to the view that our actions ought to align with those consciences. The degree to which those two aspects of our personality do align is, of course, an indicator of the relative strength of our integrity, which word literally means, from its Latin origin, wholeness of being. When we encounter unlawful demands from people such as public servants, who believe they are acting within the law, and we respond with information based upon our knowledge of the true lawful situation, it's quite normal for there to be discord and intellectual conflict. Such was the case this week, when I finally received a response from the mysterious officer with only half a name from the Therapeutic Goods Administration, TGA, who we've previously discussed. In response to my demand for the return of my confiscated property, the Nobel Prize-winning medicine ivermectin, to forestall further action on my part, I got a reiterated demand for lawful inverted commas authority to import such things. The letter was riddled with confused conflations of the terms legal and lawful. There was also a hastily cobbled together series of attempted repudiations of the validity or even the existence of Article 61, together with claims that Australian courts were unlikely to view legislation which conflicted with the Magna Carta as a problem to be concerned about. No surprises there, considering that Australian courts are all corporations with ABN numbers and operate therefore under corporate law, which is contract law. They would not want it widely known that all such entities are subject to constitutional law, which is the highest law of the land, and over which Parliament has no lawful jurisdiction. Constitutions are there to constrain the government, not the people. The people are free to act in any way that doesn't breach common law. There were also claims that laws made in Australian parliaments were binding upon all Australians, and a denial that there had been any element of threat in the TGA's original letter to me, even though it clearly stated, as we saw in an earlier video, that if I did not comply with their demands, my goods would be destroyed. Since that obviously implies a personal loss to me, it can only be realistically viewed as a threat. One might add that the listed options of heavy fines and/or imprisonment can hardly be construed as heartwarming banter. These types of attempted rebuttals are old and tired, and none of them stand up. Because, of course, it is thoroughly documented and recorded that Article 61 was invoked when we say it was, March 23rd, 2001. We have options here. I can reply giving a point-by-point answer to all these claims, or I can send the officer one of the sedition rebuttal letters, which we showed briefly in video number 16. Let's look at these again. It should be emphasized that these are only templates and, for best effect, are modified by each user to suit their individual cases. The shorter one, shown here, states simply that the response was seditious, since it overtly states that the Constitution or parts thereof are not valid, and urges law-abiding people to break the law and recognise unlawful criminal enterprises as legitimate, including the acts of overtly aiding and abetting such crime by obedience to unlawful orders, which can of course include financial support. The longer version gives a more detailed explanation of what is valid law and finishes with strong reminders of the validity of Magna Carta, its supremacy over Parliament and all other citizens, and the severity of the penalties for sedition and high treason. Openly denying the validity of the Constitution, as this officer has now done, is literal sedition, which carries the penalties of full asset stripping and life in prison. A touch more serious an offence against constitutional or common law than importing one of the most effective medicines known to man. Another alternative is to combine aspects of both these items and perhaps add a few other pointers relevant to our own situation. In this case, it seems from the dates on these replies that Officer Halfname didn't really know what to make of the notices. They certainly don't give any indication of having read the evidence presented or understanding it. It seems likely that a senior officer was consulted who trotted out these repeatedly discredited claims from those actively involved in the treason itself, i.e. law professors and court statements, etc., and told the hapless officer to send them off to me in the hope that I would be bluffed into doing as I was told. Because of the level of ignorance displayed by this minion, I feel disposed to add a few sentences which might encourage them to thoughtfully consider their own position. Questions such as, is there any possibility that my intended victim could be right and is telling the truth? If so, is there any potential risk that I could be getting myself on the hook for these serious crimes? Why isn't my boss sending out these demands? Is it possible that this boss knows more than they are telling me and is gambling that the bluff will work? And if it doesn't, that I will be the one left holding the baby and having to face any penalties, either civil or criminal? Am I really above the law, as I claim the inactive legislation says? What if there is no monarch, as is claimed? Does that mean that these pieces of legislation have not received royal or viceregal assent? The latter surely impossible if there is no former, and are thus invalid even according to the alleged legal system? These questions, which I will raise in my reply, should make this officer think a bit more than they have done hitherto. There is a letter which does raise these questions. We term it the AOM, or Act of Mercy letter, which is also a template because very few of those seeking to infringe against us are aware of the seriousness of their actions, despite perhaps having been warned already. If they want to ignore this and find themselves in hot water later with civil and possible criminal charges against them also, well, at least we've done our best to warn them. The level of conditioning to which people, especially bureaucrats, have been subjected makes it difficult to awaken many of them. But the day will come, the more people join in the resistance to treason. The response from the TGA here is illuminating. It consists entirely of stated opinions about the relevance of the legislation with which the alleged government seeks to control Australians. The assertion is that if I do not have an authority granted recognition by these alleged servants to conduct this trade, that the importation will be unlawful. We can see the confusion existing in the mind of this officer and his colleagues between what is legal and what is lawful. If I conduct a trade by which no one is harmed or defrauded, that under constitutional law is lawful. The restrictions sought by the TGA in this instance and by numerous other alleged government agencies are legal. Unfortunately for those agencies, because the invocation of Article 61 in March 2001 is irrefutable, their actions are the ones that are unlawful, for which they will eventually have to answer. The TGA response to the information regarding Article 61 consists only of a few references to case law, where judges or law professors have uttered an opinion that it is invalid or has been repealed, inverted commas. They completely fail to understand that something which is a constitutional document or law cannot be repealed by any parliament. It can only be changed by the wholesale consent of the people. Nowhere is there any attempt, as stipulated in the Notice of Conditional Acceptance, to provide proof in substance of the revocation of Article 61. Many of the claims made by Officer Halfname are laughable. For instance, that Article 61 was repealed in 1215, which is 21 years before the first English Parliament was formed. The case law quotes from a Canadian court are merely opinions, which in this officer's opinion would mean that an Australian court would say that the Magna Carta lawful rebellion scheme, which, whatever it is unrelated to our topic, would have no legal basis. Officer Halfname is therefore of the opinion, I am of the view are the actual words, that Magna Carta does not preclude the TG Act from applying to me. All laws, this is a constantly repeated error throughout the reply, passed by Australian parliaments apply to everyone in Australia. Regarding the improper conduct of officers in not disclosing their full identities, the TGA claims that this policy is consistent with all the relevant legislation, and therefore the officer's behaviour does not comprise misconduct. So according to them, I am required to fully identify myself and jump through whatever hoops they demand. But these people who are supposed to be our servants and are granted rights of anonymous dominion over those who are to pay them. My early research from a sheriff's office indicates that a major reason that these agencies are refusing to disclose their physical addresses or full names is that they receive frequent death threats from enraged members of the public who are outraged at the depredations foisted upon them and the often disastrous results. Surely that indicates to any rational person that there is serious overreach, that normally law-abiding citizens would be roused to such ire. Yet, of course, these bureaucrats strive to convince themselves that they are serving the community, in the TGA's case, by denying life-saving medication to millions of Australians. They desperately try to salve their consciences for acts which they know, if performed as private citizens, would be unlawful. Their justification? I'm just following orders. Some of us, and a growing number at that, know where that eventually leads. I'm going to enjoy responding to Officer Halfname's half-baked arguments. Until next time, thank you for watching.